morning, everyone, and again, welcome. Thank you for joining us for Davis Malm's webinar, The Ever-Changing Landscape of Employment Laws, What's on the Horizon for Employers. We're delighted to have about 60 people joining us this morning, and we look forward to your questions at the end of our presentations. My name is Tamsin Kaplan. I'm a shareholder in the employment group with Davis Malm, and our presenters for today's webinar first from our employment group include Larry Casey, Gary Feldman, Robert Cates, Taylor Lovejoy, Dave Rogers, who will be with us soon. He's in traffic, and me. Dave Rogers, by the way, is also a Massachusetts state rep serving for the 24th Middlesex District, in addition to practicing at Davis Malm. And very special from our immigration practice, we also have with us Allison Ahern-Philo, and she will be joining the panel this morning with some insights regarding immigration as it relates to employment. Again, if you have any questions, please save them for after the presentations, but we would really appreciate it if you'd enter into the question and answer box anything you have as we go along, and we look forward to getting to those questions to the full extent we can at the end. Also, you should know that we are recording today's session, and we will be sending to each of you a link both to the recording as well as to the slides after today's presentation. And now our first speaker is Robert Cates, and he will be discussing the Massachusetts Wage Act.
Thank you very much, Tamsin. Good morning, everybody. I'm very pleased to be able to present to you about the Massachusetts Wage Act, which has been and will continue to be a fertile ground for litigation, including a recent case that, to be totally candid, shocked a lot of us employment practitioners in April that I'm going to discuss. Next slide, please. The reason why the Wage Act is so powerful and is so fertile for litigation is because it offers a prevailing employee treble damages automatically plus attorney's fees and costs. This is done regardless of fault or intent, known as a strict liability statute. There's no, I didn't realize I was violating the Wage Act, or I was not aware that this is what the law is type of defense. Under the Wage Act, the president of the company, the treasurer of the company, and any officers or agents having management of such corporation are considered employees. That means they are potentially individually liable if a departing employee has concerns about whether a company is solvent or if it's in bankruptcy, then the president, treasurer, and any of those officers or agents will likely be sued. And even if not, an aggressive plaintiff's lawyer could decide to sue them. And we're seeing in litigation, the plaintiff's bar is trying to expand who's potentially liable, including passive directors potentially. And that type of litigation is winding its way through the court system currently. When terminating an employee, that employee must be paid in full all wages on the termination date. And that includes commissions that are due and payable, as well as vacation time or PTO. And finally, it's unlawful to retaliate against an employee who complains about an alleged failure to pay wages. And that's true regardless of whether or not the employee is correct or not in the employee's complaints about an alleged failure to pay wages. Next slide, please. As I said earlier, in April of 2022, a lot of us were very surprised by a decision by the Massachusetts Supreme Judicial Court. Over the last 20 years or so, there had been a common practice using a safe harbor period if there were errors involving a failure to pay wages, which would be available to an employee, or which would be available to an employer as long as an employee did not file a Wage Act complaint prior to receiving the wages owed. So for example, there's a payroll error with a recently departed employee and late payment occurs about a month later. The employer could then cure that by offering some interest payments as well. And then the employee would have no damages and would have no claim under the Wage Act. This was actually a practice that was developed under the Superior Court, our trial court level, with a decision that came out, and then was consistently upheld at the trial court level. In April of 2022, however, the Mass Supreme Judicial Court overturned the legality of this practice. And in that case, it involved a failure to pay vacation time or the late payment of vacation time 3 weeks after termination. An employee was terminated after she was convicted of theft. So this was not a particularly sympathetic plaintiff, but nonetheless, the SJC found for her. It was undisputed the employer paid the employee vacation time 3 weeks after the termination date. And then after she said to them, you violated the Wage Act, they then offered her 3 weeks of interest. So she sued, and at that point in time, she had no damages. She'd been made whole by the employer. Nonetheless, the Supreme Judicial Court held that she was entitled to treble damages on the day after discharge when she had not been paid in full all wages owed. So this was really a seismic type of decision that reinforced how careful employers in Massachusetts need to be to make sure they're not violating the Wage Act, even inadvertently or even in a way that's very small, a day late, for example. Taking next slide, please. Taking a step back and just to differentiate between what is a wage and what is not a wage. A wage includes base compensation, so salary or hourly rate, accrued vacation or PTO, and holiday pay, as well as commissions. Next slide, please. What is not a wage? Sick time, severance, and bonuses are not considered wages under the Wage Act. Now, having said that, I want to be clear about something. I don't want to leave the impression that they're not wages, so therefore there's no obligation to pay. There might be a contractual obligation to pay, but just the treble damages, individual liability of the Wage Act will not apply here. Next slide, please. So I said that a commission is a wage and a bonus is not a wage. So the question you might have is, well, what's the difference? And it's often very hard to tell, and it's something that's frequently litigated in courts, where there's something that's referred to as a bonus, but a plaintiff or an employee will argue it's actually a commission subject to the Wage Act. So a commission under the statute is something that's definitely determined and due and payable. Definitely determined means arithmetically calculable. There's some sort of formula to arrive at the number. And due and payable means all contingencies for payment have been satisfied. So if a commission is due once the employer, the company, receives payment on an invoice, then that commission is due and payable to the employee. Commissions are also generally tied to individual performance. They're tied to the completion of a sale, closing of transaction, based on an individual meeting a criteria rather than a company-wide performance, and they're usually non-discretionary. A bonus, on the other hand, is based on a company-wide performance measure, so how a company is performing, a target bonus, or based on some sort of milestone, so sign-on bonus, annual bonus, retention bonus, and it generally, although not always, gives the employer some level of discretion. Now, one thing to note is just because something's called a bonus does not mean necessarily it is a bonus. Next slide, please. So how do you avoid these types of complaints, the dreaded Wage Act complaint? One of the most important ways to avoid the dreaded Wage Act complaint is to promulgate and enforce written policies. So vacation time, PTO, commission plans, make sure they're in writing, make sure they're distributed to employees, and make sure that employees have signed them confirming their receipt of them. Next slide, please. Before terminating an employee for misconduct, make sure you're ready to pay the employee all wages, including vacation/PTO, on the date of discharge. And the SJC, in the decision in April 2022, actually said, be ready to suspend employees before terminating them if you're not ready to do so. You want to make sure your managers are very well trained and aware of the Wage Act, and you're working with counsel, hopefully your friendly Davis Malm attorneys, when dealing with severance agreements to make sure that the Wage Act is properly carved out. So thank you so much. And now I'd like to turn it over to my colleague Tamsin, who's going to talk about the Mass Paid Family and Medical Leave Act. Thank you very much.
Good morning again. So we are calling this presentation the Paid Family and Medical Leave Act 2.0, because this is generation 2. and that we're in the second year of the Paid Family and Medical Leave Act being applicable to your workers. And also, I wanted to just focus on some selected topics based on questions that I'm getting from my clients. At this point, we're, I think, all familiar with the basics. So this presentation is not comprehensive. We're just focusing on some specific questions that have been coming up over the course of the past year or so. So PFML eligibility applies not just to employees, but also to independent contractors. And this is the case when your workplace is made up of more than 50% 1099 miscellaneous contractors as workers. Services must be performed by the individual. The individual must perform the services in Massachusetts, and the individual must live in Massachusetts. Similarly, the PFML applies to former employees in some cases. Former employees can be eligible if they've worked for you within the past 26 weeks, if they're currently unemployed, and if they're unable to perform functions of their most recent job or suitable employment because of the basis of their need for the family or medical leave. Next slide, please. Another thing that comes up a lot, and my clients have questions about the overlapping of FMLA and PFML. As you all probably know, they run concurrently. Employees who take PFML leave while eligible for FMLA leave may subsequently take FMLA leave during the same benefit year, but according to the PFML, only up to the combined maximum leave time allowed under the PFML, which means that between PFML and FMLA leave, they'd only be able to take 26 weeks total. Frankly, I'll be interested to see how this plays out, because to my mind, it's not clear how the PFML can govern eligibility for FMLA leave. Definition of family members is different between the FMLA and the PFML. FMLA is just spouse, son, daughter, parent, as far as family leave. PFML also includes domestic partner, grandchildren, grandparent, and siblings. And interestingly, the PFML uses the term child, not just son or daughter, which is obviously consistent with the times we're living in and the fact that this is a new law. PFML benefit year. People ask me about this a lot. It starts on the Sunday preceding the first day of leave. As you know, the FMLA benefit year may be calculated in several ways. We recommend to our clients that they have them run the same way so that your FMLA and PFML will start at the same time and run going forward from the first day of leave. Next slide, please. Okay, domestic partners, who qualifies as a domestic partner. I won't go over this slide in detail. You have it here, and everyone will get a copy of the slides after our presentation. But I wanted to point out something I noticed that's interesting here, which is there's nothing about it necessarily being a romantic relationship with a domestic partner. It has more to do with dependence or interdependence, particularly financially and relating to family responsibilities. Next slide. Paid time off. This is an issue that comes up all the time. So if you're receiving PTO, if your employee is receiving PTO for a qualified reason under the PFML, they cannot receive paid PFML benefits at the same time. So you cannot top off or supplement PFML benefits with PTO time. On the other hand, just want to remind you that the first week of PFML leave is unpaid under the PFML. So that would be an appropriate time for your employees to use accrued PTO while the first week of PFML is running without in any way jeopardizing or reducing their PFML benefits starting the second week. PFML runs concurrently with PTO for a qualified reason, and it's important that you inform your employees so that they understand this, so that as they're taking their PTO, for example, in that first week, they know that the PFML is already running. Okay, next slide. This gets very hairy. When are PFML benefits reduced? When are they offset by other benefits that are being provided? The weekly PFML benefit amount is reduced by the amount of wages or wage replacement received from these sources. And I won't go through them because I want to zip through this so that we can stay on time. And then looking at the second section of the slide here, unless the aggregate amount that an employee would receive would exceed the employee's regular pay, the weekly benefit amount is not reduced by the following. So with respect to employees' short-term disability benefits, paid and family leave benefits that they may receive under an employer policy, wages from another employer if they have a second job or other covered business entity, or from self-employment, all of that is only going to reduce their PFML benefit if the total combined exceeds their regular weekly pay. Okay, next slide. And sometimes employers can be reimbursed for paying benefits. This is when you have not opted out because you have your own plan to replace PFML. It's rather when you are participating in the PFML program, but you make certain payments to your employees for PFML qualified reasons. So in this case, the employer does not have a private plan exemption, but makes payment to employees under paid temporary disability, your own family or medical leave policy. You may be able to receive reimbursement as long as the payments were made to the employee, again, for a qualifying reason. It's not PTO, and the reimbursement amount is limited to the amount that would have been paid to the employee under PFML. Next slide, please. With respect to retaliation, there is a 6-month presumption of retaliation. This is very important for employers to understand. Employers, of course, are prohibited from discriminating or retaliating against any eligible individual for exercising their rights under the PFML. Any negative change, this is something you must be very, very careful about. Any negative change in seniority, status, benefits, pay, other terms or conditions of employment that occur either during the leave or during the 6-month period following the leave, or the 6-month period following the employee's participation in any PFL proceedings, will be presumed to be retaliatory. Then the burden of proof will shift to you as the employer, and you are going to have to overcome this presumption by clear and convincing evidence that you would have independently decided to take the same exact action against this employee, regardless of their participation in PFML. So again, the presumption is overcome only by clear and convincing evidence that the employer had independent justification for taking action and would have taken the action in the same manner and at the same time the action was taken, regardless of the employee's exercise of their PFML rights. Next slide. Okay, so we're moving on to Gary Feldman, and he will talk about COVID-19 and the challenges that face us as employers in this year and the year ahead.
Thank you, Tamsin. Good morning, everyone. Let's spend a few minutes talking about COVID. For you employers out there, I have a feeling you've probably spent a minute or two over the last couple of years dealing with the COVID issues. The pre-pandemic era, when we used to do these seminars in our offices, I'm sure I'd see a lot of heads nodding up and down right now. So next slide, please. I'm going to spend some time talking about the issue of vaccination in the employment workplace. There's been not legislation, but there's been executive orders and a lot of attention, issuance of orders and courts striking down orders. So here's where we are at now. At the federal level, there's no current vaccine mandate for employers in place except as required by the Center for Medicare Services. So for Medicare and Medicaid affiliated entities, in the healthcare world, there is a vaccination mandate in effect. You may all recall that the Biden administration by executive order. First, OSHA, Occupational Safety and Health Administration, had issued an executive order requiring all employers of 100 or more employees to institute a vaccination or test program requirement. That program, that executive order was struck down by a federal court on the basis that OSHA did not have the authority to mandate a vaccination policy, even though OSHA's mandate is to provide for employee safety in the workplace. But a federal court, district court, struck it down, and the Biden administration chose not to take any steps to seek to enforce that. There was also, for the Office of Federal Contracting, there was also a strict, what we call a hard vaccination policy issued by executive order, requiring that all federal employees, all federal contractors, all federal employees have a hard vaccination requirement. That policy was also struck down by a federal court on the grounds that the agency had no authority, no statutory authority to issue such an order. In Massachusetts, we are one of 15 states currently at the state level with a mandatory vaccination requirement for healthcare workers. Next slide, please, Erin. Perspective of the status of the federal vaccination policies, or despite the fact that they're, other than for Medicare and Medicaid affiliated organizations, there are no current federal requirements or mandates for vaccination status of employees. Private employers may implement your own vaccination policy. And here's where we, and I'm particularly seeing a lot of questions from clients, from employers, in the absence of a mandate, of a legal obligation. So this raises a lot of issues. So private employers, you may implement a policy. And we generally refer to these policies in two buckets. The soft policy, which is what the OSHA policy was, provides for either, you may provide for either a vaccination, or for those who don't want to vaccinate or can't for any reason. I'll talk about the exceptions. It's what's called a soft policy. You will allow for testing and masking as a substitute for vaccination. A hard policy is one such as the federal government, federal contractor, or federal employee policy. There's no exception for testing. You either vaccinate or you don't come to work. Out there was a survey published in May of this year, found that reporting that over 40% of employers have one form of vaccine mandate, either a hard or soft policy, even though there's no federal requirement for such. So, and of those employers who have decided to implement a vaccine policy, 45% of those implemented what's called a soft policy. 27% have a hard policy, meaning vaccinate or lose your job, and 28% have a soft policy, but instead of testing and masking while in the workplace, have decided to block unvaccinated employees from working on site. So just for those of you who may be wondering what's corporate America doing, those are the most recent statistics as of May of this year. Next slide, please. So any vaccination policy has to include exceptions for medical conditions and religious beliefs. Unless there's an undue burden, unless the employer can demonstrate there's an undue burden. So if you have a vaccine policy in place, or you're considering one, please make sure that you have exceptions for medical condition and religious beliefs, and that's stated, and that you have appropriate forms for employees to make claim to one of the two exceptions. Next slide, please. Let's talk first about the medical exemption. The medical exemption is allowed for certain recognized indications. As per the CDC, and there's a link there in our materials to the CDC website. If you look at what the CDC identifies as contraindications, it's really limited to allergic reactions to the vaccine itself, or to demonstrated allergic reactions to previous vaccines, or any component or constituent element of a vaccine. So it's primarily an allergic reaction. In addition to that, anyone who has a history of myocarditis after having received a previous COVID shot, or having an allergic reaction to a previous COVID shot, will be someone who the CDC would recognize as having qualified for a medical exemption. Next slide, please. Is for a sincerely held religious belief, which is the same standard as under discrimination law. So the employer should assume that if someone's coming forward claiming a religious accommodation request, that they are based on sincerely held religious beliefs. That should be your starting point. Employers are entitled to ask for an explanation of the religious belief, and to ask the employee to demonstrate how the religious belief conflicts with vaccination requirements. Employers may choose to ask the employee to claim an exemption in writing, can ask about history with taking other vaccines, can ask for a letter from the employee's clergy. Demonstrating this, I read a report recently on statistical analysis of federal cases that have been brought by employees claiming either the religious or medical exemption, have overwhelmingly resolved so far in favor of the employer. Next slide, please. Here's a list of factors that alone or in combination together may undermine the credibility of a religious belief claim. And I know I'm short on time, so I will move along, but here's 4 aspects or 4 issues that you may want to look at as an employer to the credibility of a claim for religious exemption. And in both the, next slide, please. So for both the religious and medical exemptions, the employer should consider a reasonable accommodation. You have a duty to, and to assess whether the employee can perform his or her job by remotely, whether reassignment to a different office or location or position, and whether masking and or testing will be a reasonable accommodation under all the circumstances. Next slide, please. And just quickly on this is not specifically a COVID law or regulation, but in the age of the pandemic over the last 2 years, we all know that the burdens of the COVID illness fall not just on those who are COVID positive, but on caregivers, parents, spouses, support networks of people who are COVID negative, but have to give care to people who are suffering from COVID or actively sick with COVID. There's no specific protected status for a caregiver under discrimination laws. That's not a protected status, but be mindful of existing discrimination laws when evaluating requests for caregiver leave, that you don't treat female requests different than male requests. You don't approach a request for caregiver leave differently because there's an assumption that it's going to be the woman's place to stay at home and give the care as opposed to the male's place. So just be mindful of existing discrimination laws, particularly those of gender discrimination, in evaluating requests for leave to provide care. And with that, I know my time is up, so I'm going to pass the microphone over to Larry Casey, who's going to talk about ending of arbitration of sexual assault and sexual harassment claims. Thank you.
Good morning, everyone. I am going to give you a very brief overview of the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act. It's pretty straightforward. Next slide, please. Under what the Act does is it allows employees to bring sexual assault and sexual harassment claims that have already entered into pre-dispute arbitration agreements or pre-dispute class or collective action waiver. Some of you may already put those in place in the effort to avoid litigation and try to increase the speed of the process of resolving disputes. And what the Act allows is that the employee may elect that the agreement or waiver that they signed prior to the dispute not be valid or enforceable with respect to a case that they bring in court. It includes claims for sexual assault or sexual harassment. Next slide. So what the Act covers is a pre-dispute arbitration agreement, which is any agreement to arbitrate a dispute that has not arisen yet at the time the agreement was made. So all of the agreements that exist prior to the Act becoming effective are impacted by this Act, and obviously any agreements you enter subsequently. Same with the pre-dispute joint action waiver, which is an agreement to prohibit collective actions. Again, same thing. It would apply if the dispute has not arisen at the time the agreement was made. Sexual assault disputes include any non-consensual act or sexual contact as defined under applicable law, federal law, tribal law, state law. Sexual harassment disputes is a dispute relating to conduct that's alleged to constitute sexual harassment under state or federal law or tribal law. Next slide. Employers may be able to sever unrelated claims and compel arbitration. Those would be non-sexual harassment claims or non-sexual assault claims. After the harassment or sexual assault claims arise, an employee can enter into an enforceable arbitration agreement after the fact. Employees who are asserting claims can also voluntarily elect to proceed with arbitration. Again, it's all up to the employee. And it's the courts, not the arbitrators, who will determine whether the Act applies and whether the agreement requiring arbitration for these types of cases is enforceable. And that is, it's up to the court to decide, even if your arbitration agreement delegates that determination to an arbitrator. Next slide. Steps to consider that the employer should consider is whether you revise your arbitration agreements to provide for how claims that are not sexual harassment or non-sexual assault claims will be handled. You can revise your agreement to exclude the arbitration agreement to exclude sexual assault or sexual harassment claims. So your wage claims, any other types of disputes that might arise would be arbitrable. You could include a provision in your arbitration agreement requiring that sexual assault or harassment claims be severed and stayed pending the completion of claims that are arbitrable, which would be the non-sexual harassment or non-sexual sexual assault claims. The one thing to consider, though, is what are the pros and cons associated and the costs associated with creating dual form litigation, meaning you'd be arbitrating the non-sexual harassment and non-sexual assault claims, and then also be in court for the claims concerning sexual assault and sexual harassment. There is a question under the Act as to whether when a claim is brought, it references the word case and whether the statute will be interpreted to include all claims, whether they're sexual assault or sexual harassment. And any of these revisions that I've suggested to be considered, it's an open question as to whether the court will accept them or not. Next slide. So that's the Arbitration Act. What I want to now go over is Mass Equal Pay Act. Next slide, please. So this act was effective back in July 2018. It's been in place. I frankly haven't seen as many claims as I thought I would under the statute, but it does apply to all employers in Massachusetts. Next slide. So the act, generally speaking, there's four kind of buckets. The act provides 6 bases where you can provide variable pay. It restricts what employers can ask about an applicant's pay history. It makes it unlawful for an employer to prohibit employees from discussing wages, either their own or other employees' wages, with one exception. And then it provides an affirmative defense to the employer if you've conducted a pay audit within a requisite period of time. Next act. So basically what the act prohibits is that an employer cannot discriminate on the basis of gender in the payment of wages, or pay a person salary or wage at a rate less than rates paid to employees of a different gender. The key issues here are what are wages and comparable work. If there is an unlawful wage differential, the employer cannot reduce the wages of an employee to comply with the act. So you can't bring down the wages, the high paid person, to bring them to the low paid person and say, oh, guess what? Now there's no discrimination. Next slide. So wages are defined broadly. They are defined as all forms of remuneration for employment. That includes wages, salaries, bonuses, commissions, health insurance, and other fringe benefits. So you would have to compare the whole package as between the genders. Next slide. Comparable work is defined as work that requires substantially similar skill, effort, responsibility. It's performed under similar working conditions. There are some areas where employers can account for differentials like reasonable shift, differentials, physical surroundings, and hazards. A job title or job description is not going to determine whether a job is comparable. They're going to look at the facts and as to the skill, effort, and responsibility and working conditions. And substantially similar is not defined in the act. So it's going to be fact-based and doing a comparison between jobs. Next slide. So I mentioned there are ways under the act where you can differentiate and pay between the genders. And the 6 bases are when it's based on a seniority system that's in place, a merit system, a system measuring quantity or quality of production, sales, or revenue. It can be differentiate based on education, training, or experience that's related to a specific job. And geographic location of job performance is another differential. And travel, if travel is a regular and necessary condition of the job. Next slide. So what's the analysis to do? The analysis first, are the jobs comparable? You look at the skill, effort, responsibility, and working conditions as between the two jobs and make a determination. Is there pay equality between men and women? So that's a comparison of salaries and including wages, benefits, fringe benefits. Is there a pay differential between genders? And essentially, is it based on any one of those 6 factors? And you are limited to one of those 6 factors. That's the only thing that the statute recognizes as a basis for differential in pay. Next slide. So what happens if you don't comply with the act? An employer is liable for the amount of unpaid wages. That would be the difference between whether you paid a female more than the male or male more than the female, plus an equal amount as liquidated damages, plus reasonable attorney's fees and costs. The employee can file their claim directly in court. Unlike with discrimination claims, they don't have to go to the MCAD first. And unlike wage claims, they don't have to go to the Attorney General first. An agreement by the employee to work for less is not a defense. The employee's previous compensation history is also not a defense. And interestingly, and of significance is there's a 3-year statute of limitations. So the employee can bring a claim anytime within 3 years after there's been a violation, and a violation occurs every time wages are paid. So the ability to file these claims continues to roll along as time passes with employees being paid unfairly as between genders. Next slide. So under the act, what are the unlawful employment practices? In a nutshell, you cannot prohibit employees from discussing their own or other employees' compensation. You cannot seek compensation history from a prospective employee, and you cannot require that a prospective employee prior compensation history meet certain criteria. What an employer may do is confirm prior compensation if the prospective employee voluntarily discloses their compensation, or after you make an offer to the employee with the compensation amount, and that's been negotiated and made to a prospect. You can then determine and ask to check on what their compensation had previously been. Next slide. So here's the bonus that's given to employers is you get an affirmative defense if you undertake and complete a self-evaluation of pay practices within the previous 3 years before a suit is filed by the employee. And you have to demonstrate reasonable progress towards eliminating wage differentials based on gender for comparable work. So you get a complete defense to the claim if this self-evaluation was done in good faith and reasonable detail and scope. The evaluation has reasonable detail and scope. And of course, you meet the two elements I mentioned up above. It's a partial defense if you can't demonstrate the evaluation was reasonable in detail and scope. You have to still meet the other criteria. And what you do get as a partial defense is you're not liable for that liquidated damage payment, which equals the amount of the difference in wages. Evidence of a self-evaluation or that you've taken remedial steps to eliminate pay inequality is not admissible as evidence of a violation. There are certain time restrictions to that, but we don't have time to get into all those details. So I think, next slide, I think that does it for me. I'm going to turn this now back to Robert Cates. He's going to talk to you about learning from high-profile mistakes, properly investigating and correcting workplace discrimination harassment.
Thank you, Larry. Good morning again. As both a big hockey fan and also an employment lawyer, there was a scandal in the hockey world over the last 6 months where the fallout's still ongoing that really caught my attention. And it involved a franchise worth $1.4 billion, and they so thoroughly botched a response to a sexual harassment complaint that they've been taking on a significant amount of terrible publicity. And we felt that this was really an illustration about based on how thoroughly the Blackhawks failed, how it's an illustration of how to properly investigate and correct workplace discrimination harassment. Next slide, please. So what happened was in May of 2010, a video coach and a top prospect who was 19 years old for the Chicago Blackhawks had sexual contact at the video coach's apartment. What happened is in dispute. The video coach claimed it was consensual, although obviously this was a supervisory employee off hours with someone who essentially reported to him. So it had some quid pro quo elements to the sexual contact. The top prospect claimed it was a forcible assault, that there was no consent, that it was against his will, and that it was in effect a sexual assault. Within days of the incident, the top prospect came forward. He did not make it clear that he was alleging a sexual assault, but that something inappropriate had occurred and that he was uncomfortable with what happened. Basically, the entire brain trust of the organization came together to meet how to discuss it. That included the president, the general manager, the coach, as well as several other high ops people to discuss the allegations. It was in the midst of the Chicago Blackhawks playoff run, and they decided we'll table handling it until after the playoffs end. That year they won the Stanley Cup, so the playoffs lasted for a while. Next slide, please. After the playoffs ended, Human Resources met with the video coach, said, well, you can either resign now, we won't say anything about this incident, or you can stay pending an investigation, and if we find that you did something inappropriate, violated our practices, then we will terminate you. So the video coach elected to resign, but he was essentially treated as an employee leaving amicably. So he was attending all of their postseason functions, and again, making the victim uncomfortable, feel ostracized and marginalized. And that continued into the next year. The prospect reported that he was mocked and ridiculed by his teammates for his relationship with the video coach. And the prospect, who was a first-round draft pick, number 11 overall, and was 19 at the time with a very promising career, ended up washing out of the organization and playing in Europe. Next slide, please. So, as any employment lawyer will know, this was a ticking time bomb. You had a predatory video coach and an organization that was unable or unwilling to address it. Several years later, the video coach was arrested and convicted for indecent sexual assault on a minor in Michigan. And this was a hockey player on a high school team. The video coach had leveraged his time in the NHL to get jobs at colleges and high schools. And as more information comes out, it turns out he was predatory with young men and young boys. The family of the victim filed suit against the Blackhawks in 2021. And the top prospect who had come forward in May of 2010, he also filed suit in 2021 after he learned about the video coach's arrest and conviction. Blackhawks organization commissioned an independent investigation. The independent investigation was very critical of the Blackhawks organization, and the investigation report was released publicly. Next slide, please. The fallout was clear and swift from the Blackhawks' failure to investigate and remedy the sexual harassment. On top of terrible publicity, there was a predatory individual who was allowed to continue to work with hockey teams, particularly college and high school hockey teams with younger boys. A top prospect did not realize his potential for the organization. So this was a promising young employee who could have given years of service to the employer, and he was not able to do so. The NHL fined the organization $2 million. The Blackhawks settled the lawsuits against them for significant money, even though they likely had very strong defenses on statute of limitations grounds because the incidents had occurred more upwards of 10 years earlier. And the current GM of the Blackhawks and the coach of the Florida Panthers, who was the coach of the Blackhawks at the time, both resigned due to their roles, and they're essentially personas non grata in the NHL at this point. Next slide, please. So the question is, how do you not beat the Blackhawks? And that requires, once a report of harassment or discrimination is brought to your attention, it should be investigated promptly and thoroughly. And the investigation should be done in a manner that's designed to uncover the truth rather than protect the company. And I think employers, when conducting investigations, should understand that sweeping things under the rug is not protecting the company. If you have an employee in your midst who's engaged in discrimination or harassment, it's not protecting the company to treat that employee with kid gloves or act like what happened didn't happen. The best thing is to address it and remedy it as soon as possible. Otherwise, it's probably going to happen again. This video coach was a predator and was likely to engage in some similar misconduct in the future. So this is the type of thing that employers need to be aware of. The best way to protect the company is to uncover the truth and then take steps to correct it. So while the investigation is ongoing, the alleged perpetrator should be separated from the alleged victim. And confidentiality during the investigation should be maintained to the greatest extent possible. The keywords to the greatest extent possible. Confidentiality is not something that can be guaranteed, but it should be the best practice is to keep it as confidential as possible. Documentation during the course of the investigation, notes of witness interviews, notes of action plans, reports, written warnings into employee files, personnel files, once corrective action is taken. If there are sticky situations about what corrective action is appropriate under the circumstances, then you should consult with employment counsel about that. And then finally, you should be sure not to retaliate against the victim, even regardless of whether or not the victim has alleged something that's actually actionable harassment or discrimination. That employee has engaged in protected conduct and cannot be subjected to retaliation for that protected conduct. So thank you very much. And I'm going to now turn it over to Tamsin Kaplan, who's going to talk about the Massachusetts Non-Competition Agreement Act. Thank you very much.
Good morning again. Thank you, Robert. Okay, next slide. What agreements are covered by the Massachusetts Non-Compete Agreements Act? The Act covers any non-competes from October 1st, 2018 through the present that are made in anticipation of or during the employment relationship. So before employment or during employment, and they're non-competes, so they prohibit the employee from engaging in specific activities that are competitive with the employer after employment ends. This includes both employees and also independent contractors under the three-prong test. Okay, next slide. What agreements are covered? Non-competes made in connection with separation from employment are governed by the Act only when the employee is not expressly given 7 business days to rescind. So again, the Act applies to non-competes that are pre-employment, during employment. It only applies to post-employment agreements that do not explicitly provide a 7-day revocation period. So as long as you put in a 7-day revocation period in a non-compete that's contained in a separation agreement, then you're out from under the restrictions of the Act. Okay, next slide. Non-competes are unenforceable against non-exempt employees, undergraduates or graduate students in internships or short-term employment, employees terminated without cause or laid off. So non-competes under the Act are not enforceable if you terminate someone without cause or lay them off. However, as we just learned, although you cannot impose a non-compete pre-employment or during employment, that will apply post-employment if you terminate the employee without cause or lay them off. Post-employment, you can put in place a non-compete at that point in exchange for appropriate consideration, as long as you give the employee at least 7 days to revoke. And you cannot impose a non-compete against someone who's 18 or younger. Next slide. Okay, more minimum requirements under the Act. It must be a written non-compete that's signed by both parties. It must expressly state the employee's right to consult with counsel before signing the non-compete. And by the way, when I talk about the non-compete, this can be a standalone agreement, an agreement with other restrictive covenants, or an agreement that's part of a general employment agreement, or even an offer letter that constitutes an employment agreement. Prior to employment, provided the agreement must be given to the employee earlier than the formal offer of employment or 10 business days before commencement of employment. And if the non-compete is provided during employment, it must be 10 business days before the non-compete takes effect, and you must provide fair and reasonable consideration, not just continued employment, for the actual signing of the non-compete or entering into the non-compete. This is separate from consideration for the obligation. This is during employment. If you ask an employee to sign a non-compete, you cannot just reward them or compensate them for signing that non-compete with continued employment. There must be some reasonable and fair consideration, such as a bonus, such as doing it in conjunction with a raise and promotion. Okay, next slide, thank you. More minimum requirements. This has to do with the scope of the non-compete itself. This is very important. These are some aspects that have been baked into the Act that were prior law in Massachusetts under common law, court-made law. The restrictions of the non-compete can be no broader than necessary to protect the employer's trade secrets, confidential information, and goodwill. So it's presumptively necessary only when the interest cannot be adequately protected by an alternative restrictive covenant. And this is something that employers need to think about. Your non-compete should be narrowly tailored, specifically to protect your legitimate business interests, your trade secrets, confidential information, and goodwill. And it must protect your legitimate business interests in a way that would be impossible to protect via another restrictive covenant, such as a non-compete or confidentiality or trade secrets agreement or provision. The agreement cannot exceed a 12-month restricted period post-employment. It can extend up to 2 years total duration in a situation where an employee breaches a fiduciary duty or unlawfully takes company property. It must be reasonable in geographic scope. It will be presumptively reasonable under the Act if the geographic scope includes the places in which the employee provided services, had a material presence, or influence within the last 2 years prior to separation. And it must be reasonable in terms of the scope of the proscribed or prohibited activities. Again, presumptions under the Act, it's presumptively reasonable if limited to the scope of the employee's activities within the past 2 years prior to separation. Next slide, please. More minimum requirements. All right, so this non-compete that's given pre-employment or during employment can only be enforceable if it is supported by consideration. The consideration should constitute either a garden leave clause, which we'll discuss in 1 second, or other mutually agreed compensation. And many people have asked me, well, I don't want to give a garden leave. I don't want to give that much consideration. What is other mutually agreed upon consideration? And at this point, the courts, although they've mentioned the Non-Compete Act, have not really delved into any interpretation of the Act. So we don't have any guidance with respect to what could be other mutually agreed upon consideration for the non-compete obligation. What I'm seeing and what I'm advising my clients to do is provide the garden leave. So what is garden leave? Garden leave becomes effective upon separation. It is pay that is equal to 50% of the highest annualized base salary within 2 years prior to separation. It is paid pro rata over the restricted period. So if you have a 12-year non-compete, you're paying it generally along with your regular payroll, unless the non-compete is breached by the employee, in which case you may stop paying, or you may extend the length of the non-compete and not pay for the extension. So as you see here in the bullet at the bottom right, pay is not required during an extension of the restricted period beyond the 12 months. And that extension would occur in the case of a breach of fiduciary duties, theft of company property by the former employee. Next slide. Okay, enforcement of non-competes. The courts have discretion to what we call blue line the document. So they can reform or revise to render the non-compete valid for protection of trade secrets, confidential information, and or goodwill. And this next one is very important and interesting. Choice of law provisions to avoid the requirements of the Act are unenforceable if the employee has been a Massachusetts resident or employed in Massachusetts for 30 days or more at the time of separation from employment. So if an employer employs someone in Massachusetts who lives in Massachusetts within the last 30 days of their employment, they cannot, through the contract, apply another state law so as to avoid the restrictions of the Massachusetts Non-Compete Agreements Act. Even if, say, the company is located in another state or incorporated in another state. And actions to enforce must be brought in the county where the employee resides or in Suffolk County by mutual agreement. If in Suffolk, in the Superior Court or in the business litigation section of the Superior Court specifically. Okay, next slide. These are the areas that are not covered by the Act. Non-competes that are made in connection with separation from employment. We talked about this already. When the employee is expressly given 7 business days to rescind acceptance. Non-competes outside of the employment relationship. Non-competes made in connection with the sale of a business or substantially all assets or ownership interests of the business. When the restricted party is a significant owner of or member or partner in the business entity. And when they receive significant consideration or benefit from the sale. These are non-competes that are outside the coverage of the Act. And one more slide, I think. The act does not cover other restrictive covenants such as non-solicitations or covenants not to hire or rehire, covenants not to hire rather other employees, or for that matter to poach or to interfere in a relationship with employees. It does not apply to covenants not to solicit or transact business with customers, clients, or vendors, or interfere with those relationships. It does not cover confidentiality agreements, invention assignment agreements, covenants not to reapply for employment. Okay. So now we're moving on to joint employer status, and this will be presented by Taylor Lovejoy.
Good morning. So as Tamsin said, I will cover joint employer status briefly. It's a topic that may not be as exciting as some of the others here, but it's very important because of the substantial consequences that can arise if joint employer status applies to you. So next slide, please. So the question is, what is joint employer status? It applies when, for purposes of minimum wage and overtime requirements, the Department of Labor, both at the federal and state level, will consider two different companies to be a worker's employer for the same work that gets performed. So as an example, a joint employer relationship could exist where a hotel contracts with a staffing agency to provide cleaning staff, but the hotel directly controls what the cleaning staff does. They cut their paychecks, they tell them which rooms to clean, they tell them where to go. If the agency and the hotel are joint employers, then they both become responsible for worker protections. And this doctrine determines the scope of employer liability in a lot of different settings, including franchise relationships, independent contractors, and contingent workers. There are two general types of joint employment. The first is vertical joint employment, which is the example I just gave. It's when a worker is employed by one employer, but is actually economically dependent on another employer above them that receives the benefit of the worker's labor. And that's what we typically see. There's also horizontal joint employment, which is a little less common, but we see it more often in franchise relationships, which is where two or more entities employ the same worker for separate hours within the same work week. So an example of this could be if you have an employee at a McDonald's, they pick up 3 shifts at one location, they pick up 2 shifts at another location. Both McDonald's franchises are considered a joint employer, depending on how the analysis falls. The main takeaway with this is that under both the Fair Labor Standards Act at the federal level and the Massachusetts Wage Act, there are substantial financial consequences if you are analyzed to be a joint employer and you fail to pay compensation, you misclassify an employee, or you engage in unfair labor practices. So as I said, it's very important to understand whether or not it applies to you. Next slide, please. Over the past decade in particular, there's been a lot of back and forth as to what a joint employer is under federal law, which is the primary body of law that governs when it applies. For a long time, the National Labor Relations Board, which is a quasi-judicial agency at the federal level, has issued decisions as to what a joint employer is, how to analyze it under the Fair Labor Standards Act. But the Trump administration, briefly before Donald Trump left office, went through a proposed rulemaking to pass what's called the Joint Employer Rule, which was on the books for about 1.5 years. And this was published in the Code of Federal Regulations. It was a rule that outlined a set of factors that you see here, 4 rigid factors that are to be applied to determine whether or not there is a vertical joint employment relationship. The touchstone of this analysis was whether or not an entity exercised actual or actually exercised control over the employee. Not whether they could or whether they had the power to, but whether they actually did. And courts were only supposed to consider factors outside of these 4 if they led to the same point. In other words, if they showed whether or not a potential joint employer exercised significant control over the terms and conditions of the employee's work. Considering an employee's economic dependence on a potential joint employer was explicitly prohibited. And as for horizontal joint employment, the rule didn't really change much. The analysis was then and is now and has been, if employers are sufficiently associated with respect to employment of the employee, then they may be considered horizontal joint employers, and they'll have to aggregate the number of hours worked in order to determine compliance with the FLSA. Next slide, please. Now, as with a lot of policies for Donald Trump's administration, there was significant pushback shortly after this rule was passed and put on the books. 17 states and the District of Columbia filed suit against the Trump Department of Labor in the Southern District of New York, and the court ended up vacating substantial portions of the rule for the three general reasons that I've outlined here. The court found that it was impermissibly narrow because it focused so closely on actual exercise of control, rather than the suffer or permit to work approach that the Fair Labor Standards Act takes and the Department of Labor had taken before. It also looked only at the definition of employer as opposed to the definitions of employee and employ, which are found in other places in the Act. It was novel in that it disagreed with past Department of Labor understanding of how to apply the analysis. And it was nebulous because it didn't adequately consider the cost to workers if the number of joint employers decreased as a result of the rule. Also, the test for whether an entity was the primary employer was entirely different from the test of whether you were a joint employer, which could lead to inconsistent application. Next slide, please. But in the end, as has been the case with joint employer status throughout the years, the court's determination and decision ultimately became moot because the Biden administration, once Joe Biden came into office, wiped the JER off the books in its entirety and took away the rule for many of the same reasons that the court did. It was inconsistent with past guidance. It was an inaccurate interpretation of the FLSA, and it had too narrow focus on employer control, which was contrary to pre-existing federal court analysis. Again, it also didn't adequately consider the impact on employees. The Biden Department of Labor was particularly concerned with the impact of the rule on women and people of color and agricultural workers, people who tend to work with staffing agencies more frequently than other demographics. And the Biden Department of Labor also looked at the business community to determine, well, what would be the real impact of taking away the rule? And it didn't find that there would be any impact on the business community, despite concerns that popped up by businesses during the rulemaking process, because many courts didn't end up taking the joint employer rules factors into consideration when doing their own analysis. They continued to go their own way as they had before. Next slide, please. So that leaves us with where we are now and where to go next. Well, where we are now is that we're basically back to there is no rule. There is a disjointed analysis by federal courts and state courts across the country that tend to apply their own what are called totality of circumstances analyses. The scope of vertical joint employment is, again, a lot wider. If a worker is formally employed by your business, meaning that you have the ability to make decisions concerning that individual, even if you don't actually do so, you may be considered a joint employer under the vertical joint employment analysis. As for horizontal joint employment, the question you have to be concerned with is, do two employers together control the employee's services, what that employee does, either by contract or from a practical perspective, from Monday to Friday or from a typical work week as it applies to your business. Federal and state courts, so long as they stick within these bounds, will get to consider their own set of factors under a totality of the circumstances analysis, as they had done prior to the joint employer rules passage. The federal government, at least from Biden's Department of Labor, has said that it's going to stay relatively silent in passing rules in the future. Its approach is going to be to look at the text of the FLSA and determine whether or not you are a joint employer under the exact text as it sees it before considering whether or not to go down the route of proposed rulemaking again. So the reality here is that this is a political animal, this doctrine. It will change from administration to administration, from party to party. So it's important to keep an eye out when new administrations come into office, which we may be facing in 2 years, and to make sure that you stay updated when courts in your jurisdiction come out with rules. And of course, we will continue to update with changes as well. So with that, I'll turn it over to Allison to discuss compliance with immigration laws in a remote worker world. Thank you very much for your time.
Good morning. Thanks, Taylor. Today, I'm going to focus on some key requirements to comply with U.S. immigration law with remote workforces and some general considerations when hiring foreign nationals as employers feel the impact of the current labor shortage here in the U.S. Next slide, please. So one of the fundamental requirements of US immigration law is properly completing an I-9 for every employee hired. And that involves physically inspecting the List A document or List B and List C documents taken together, presented by the employee within 3 days of the start of employment. And again, that requirement is physical inspection, meaning in-person inspection of the document when completing Section 2 of the I-9. So because so many workforces have gone full remote, the Department of Homeland Security has provided a flexibility stating that those documents can be inspected remotely. And that flexibility was recently extended to October 31st, 2022. And again, the remote inspection can occur over Zoom, Microsoft Teams, some sort of video link, or the employee can provide scans, photocopies of the List A document or List B and List C documents through email, and they can be inspected that way. Next slide, please. So the specific language of the temporary exemption from the physical inspection requirement is that if employees for employees hired on or after April 1st, 2021, if they work exclusively in a remote setting due to COVID-19 precautions, they're temporarily exempt from the requirement that employers physically inspect, meaning verify in person, the List A document or the List B and List C documents when they complete the I-9. When these workforces return to in-person employment, the employers must physically inspect those documents, or they must physically inspect the documents when this temporary exemption expires. And as I mentioned earlier, the temporary exemption is due to expire right now on October 31st, 2022. It has been continuously extended since March of 2020. So there's an expectation that it may be extended beyond October 31st, 2022, but that's a date to watch out for when considering when does the employer have to physically inspect the document presented by the employee to prove their employment eligibility. If the employee has returned to some sort of hybrid setup or is coming into the office on a regular, consistent, predictable basis, that temporary exemption no longer applies and the employer has to physically inspect that document in person. And I provided a link there for the specific language of the exemption if you'd like. Next slide, please. So because the language of the rule is specific about the exemption going into effect on April 1st for employees hired on or after April 1st, 2021, the question is, what about employees hired between March 20th, 2020 and April 1st, 2021? And for that period of time, for employees hired during that period, the Department of Homeland Security has said that they will evaluate I-9s completed on a case-by-case basis. So I think that means that, you know, best practices, if you inspected the document remotely, document that fact on Section 2 of the I-9, write that remote inspection occurred on month, date, year, and who inspected the document remotely. And that generally is, the Department of Homeland Security has indicated would be acceptable. Again, as long as the workforce was fully remote. If the employee was coming into the office during that time, that remote inspection would not comply with the requirement to physically inspect the document A or the documents B and C taken together. Next slide, please. Again, like I said, the remote inspection can occur over video chat, or the employee can look at scans of the documents that are sent by fax or email. And the I-9 requirement is that that inspection occur within 3 days of the employee starting the employment. Next slide, please. So, as workforces continue to be remote, for employees who are on a work visa, there are very specific considerations. I highlighted one here for employees using the H-1B work visa, which is the most common type of work visa in the US. Again, this would be a foreign national using an H-1B work visa to work. If they have gone remote, meaning they're hired pre-COVID, and at some point in the past 2.5 years, they have moved to a completely new residence, or they're reporting to a different office, the work site location on the visa has to be amended, because that work site location is tied to the required minimum wage, and it's tied to how often the employee has to report to an office. There are very specific considerations. So for employees on work visas, it's important to look at where is he or she working, and when the company did go remote, did that employee move, and did they move outside of a normal commuting distance to the worksite location that was listed on the work visa application. Next slide, please. So now I'm going to go into some general considerations when offering employment to a foreign national, which is becoming more frequent due to the US labor shortage. I get a lot of questions from employers who are considering hiring a foreign national who's located inside the United States, or a foreign national who's located outside of the United States, meaning they want to bring them into the US to work for the company. So for foreign nationals who are located inside of the United States, they're typically on some other type of visa, whether it's a student visa or a visitor visa, and they apply for the job. And the first major consideration is what questions can the employer ask during the recruitment about that person's eligibility to work in the United States? Because the questions cannot be, are you a US citizen? They can be, are you authorized to work in the United States? Or do you require visa sponsorship? They can be open-ended like that, but they cannot get into the specific eligibility to work in the United States in order to not violate discrimination laws. When the prospective employee says, yes, I need visa sponsorship, then there are questions that the employer should ask to make sure that visa sponsorship is possible. And those, are specific. They can be, how long have you been on a certain type of work visa? What other visas have you held in the past? Have you ever had a green card process initiated for you? Those are good questions to ask. And I put that the most common transition for foreign nationals located inside the United States who are applying for jobs here is the student visa to optional practical training to H-1B timeline. So that is student attends school here in the United States, graduates with a degree, is able to work on an extension of the student visa, which is referred to as optional practical training, to get training within the United States in his or her field of study. And then the optional practical training is valid for 12 months, or for STEM fields, it's valid for 36 months. And then during that period, the employee has to transition to an H-1B work visa in order to continue working here for over the next several years. For foreign nationals located outside of the United States, there are a lot more considerations regarding timing and logistics, because that application for a visa to bring someone over has to go through the US Department of State. The US Department of State is still severely backlogged due to COVID. And so not only is it trying to plan out some sort of timeline, for when the employer can expect that the employee will be able to fly to the United States. There are also COVID-19 related travel restrictions. So the employee who's coming into the United States has to be fully vaccinated with acceptable vaccination, which is not always the case in certain countries. So in terms of, again, when will the employee be physically present in the United States and be able to start working, that's more challenging when they're currently outside of the US. I did include that TN visas for Canadian or Mexican nationals. Those are special visas for Canadian citizens or Mexican citizens with offers of employment for certain professional occupations. Those are more predictable in terms of timing, because Canadian citizens can apply for these visas at the port of entry at the border, and Mexican citizens can apply for these visas directly to the US Embassy in Mexico, and the timing for that is not as uncertain. And that is all I have for you this morning. I will hand it off to Dave Rogers with updates from the State House. Thank you so much.
Well, good morning, everyone. It's good to be with you. And in addition to practicing law here at Davis Malm, I do serve in the Massachusetts House and want to give you a couple brief updates on what we're doing. Please go to the next slide. Both the House and Senate have passed the Crown Act, which prohibits discrimination based on natural hairstyles. That could be braids, locks, Bantu knots, and other formations. And it amends, while this is primarily focused on what has transpired in schools, and that's what sparked the need for it, it does amend our major anti-discrimination law, Chapter 151B. So this would be a protected category, and discrimination in this category would be subject to lawsuits, just like disability, gender, and other protected classes. While it's cleared both the House and the Senate, it's not yet law because the House and Senate versions are different. They'll be negotiated and then presumably sent to Governor Baker for his signature. But it's a new protected class, so we just want you to be aware of it. Next slide, please. The next major thing I want to touch on is a ballot question that's looming here. As I'm sure you know, just like we make law through the state legislature, we do have direct ballot questions where voters approve laws. And there's a big one looming this year. Maybe you've seen the ads on television for Uber and Lyft drivers. It's the independent contractor law that is in question. And our independent contractor law in Massachusetts is a robust law and has three major parts. One is that the individual is free from the control and direction of the entity they're working for. So think of Uber and Lyft drivers. They set their own schedule. They don't have to report at a specific time. The second prong is that the service is performed outside the usual course of the business of the employer. And that's the key one, which I'll get to in a minute. And finally, that the individual is customarily engaged in that trade or occupation. So like a worker who drives could work for Uber, can work for both Uber and Lyft. So they're customarily doing this work. Next slide, please. But the key is that second prong, that it's outside the usual work of the employer. And that's the second prong. And it's what is often in question in litigation and in deciding whether a worker is an independent contractor or an employee. And the consequences for misclassification of an employee, calling them an independent contractor when they're really meet the test of employee, is huge. I mean, taxes at both the federal and state level. It could be unpaid overtime, vacation time. So it has huge implications. Next slide, please. So just a couple quick examples. So if a hotel tries to classify the cleaning service that cleans the rooms, and this has happened, as an independent contractor, it's been held that no, because it's not outside the usual course. The hotel tried to say, well, we provide rooms, they provide cleaning. And the judge said, no, 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 you provide clean rooms. And so they are fundamentally part of your business. And so they were improperly classified. Our Attorney General here in Massachusetts is currently suing Uber and Lyft, claiming they're in violation of the independent contractor law. And as a consequence, advocates for these companies are putting forth a ballot question. Next slide, please. So the ballot question, if it reaches the final ballot in November and Massachusetts voters approve it, would classify these drivers as the app-based drivers as independent contractors. And it has some minimal provision for benefits for them. While it is confined at this moment to app-based drivers, most analysts, employment lawyers, and others believe that if this wall cracks and that law is changed, our independent contractor law is changed in that way, it will be the beginning of a flood of changes to the independent contractor law with very big implications for employment law here in Massachusetts. So finally, I'll note that if you have any questions at any time about what is pending in the House or in the legislature, please get in touch and I'm happy to provide information. So thank you very much, and I'll turn it back to Rob.
Hi again, everybody. We're going to do a very quick Q&A. We're going to go until 9:35. Of course, if any of you have questions that were unanswered, please don't hesitate to reach out to one of us. The contact information is on the screen for each of us. There was one of the easy housekeeping questions I can answer was, will the slides be shared with us? Yes, anyone who attended or signed up will receive the slides after this presentation ends. Question that I received during the Wage Act presentation were, are treble damages calculated based on disputed late payment amount? Yes, that's correct. So just to give an illustrative example, let's say there's a dispute between employer and employee about the value, about the amount of vacation time. The employer pays $1,000, the employee believes they're entitled to $5,000, so a difference of $4,000, and the employee ends up prevailing. In that case, then the full $5,000 isn't subject to trebling. It would be the $4,000 that was unpaid. Now I saw a question that got upvoted a couple of times relating to the Paid Family and Medical Leave Act. This is a question for Tamsin. What about employees who work remotely out of state? Are they entitled to paid family and medical leave?
Yes, Rob, they are. As long as the employer is located in Massachusetts, it doesn't matter where the employee is located. They are entitled to PFML.
A question for Taylor. How does Massachusetts deal with the joint employer status?
So Massachusetts takes the same tack that a lot of other courts did, as I mentioned during my presentation. Courts typically apply a totality of the circumstances test, and Massachusetts is no different. An important thing in Massachusetts, though, is that it has the Massachusetts Wage Act. And just recently, in December of last year, the Supreme Judicial Court held that even though the Mass Wage Act does not explicitly define joint employer or include that term, that concept is baked in. And so if you are found to be a joint employer under Massachusetts law, you can be held liable for wage violations and the amount of treble damages, face attorney's fees, and the like. But to answer your question, they do use a totality of the circumstances test. They use 4 factors that are very similar to what was used under the Trump joint employer rule.
Great, thank you, Taylor. A question for Allison. What should we do if an employee hired after March 2020 leaves before we return to the office and we're never able to verify the documents in person?
So the Department of Homeland Security has said in those cases, documenting it on that employee's I-9, so that when the remote inspection occurred, and then writing in Section 2 that the employee left prior to the workforce coming back to in-person employment, or left prior to the temporary the exemption being lifted.
Great, thank you, Allison. So I received a question about the presentation I had given about correcting and remedying workplace discrimination and harassment. First question was, when interviewing witnesses for the investigation, should there be a witness present? In an ideal world, that would be a best practice if you're a large company with a robust human resources department and you can staff multiple people to attend a witness interview. That's certainly the best practice, the safest practice. With regard to smaller companies, though, it may be difficult to be able to conduct an investigation with a witness present, given you want to maintain confidentiality to the maximum extent possible. Bringing more individuals into the interview room will obviously open it up more. So that might not necessarily be feasible. That's why it's so critical to document the meetings, document the interviews, and take notes to memorialize what was discussed, what was learned during those interviews. You never know when it might be relevant a couple of years down the road. And then the second part of the question was, when should outside counsel be brought in to handle the investigation? I think anytime where there's a question about partiality of the person who would do the interviews or do the investigation, then outside counsel absolutely needs to be brought in. A couple others is if person inside the company doesn't feel comfortable conducting the investigation or has some misgivings about it, absolutely outside counsel, as well as when there's complex and nuanced issues of law and fact. That's where it's very helpful to be able to lean on outside counsel to do the investigation, because outside counsel already has knowledge of the existing law, the legal standards, and how to sort of parse through those complicated facts. So that's a great two-part question. And then the final question in the Q&A is about the COVID presentation for Gary. If an employer is considering an employee's request for a religious exemption to its vaccination mandate, is it required that the religious basis offered by the employee is consistent with an established religion or religious doctrine?
That gets into the gray areas of the exemption. The basic answer is no, it does. The claimed exemption does not have to be based on a belief consistent with one of the major established religions. The EEOC and the courts talk about a bona fide religious belief, and the EEOC has, in its guidance, has instructed employers that what it calls idiosyncratic beliefs are entitled to accommodation to the extent they're sincerely held. One example, as I recall, that the EEOC gives in that instance is an example of a Native American employee who had a dream where a spirit came to him, I believe it was a male, and instructed him not to cut his hair. And action was taken against him for violating the company's dress code, and his belief, his practice of deciding not to cut his hair was upheld and entitled to religious accommodation. So it would be on a case-by-case basis, but in terms of having to come a doctrine from one of the established worldwide religions, it's not necessary.
Thanks, Gary. I'm gonna turn it back to Gary actually to conclude the seminar. So thank you very much for those great questions.
So thank you everyone for joining us in our employment law seminar. We miss you all. We miss doing this in our offices, and hopefully we look forward to being able to do that next year. We appreciate everyone, of course, taking the time to be with us. We hope this was informational for you and helps you in your day-to-day experiences in the workplace. As Rob mentioned, feel free to reach out to any of us individually if you have any questions that have not been addressed, and we'll respond to you offline. Special thanks to our marketing team of Joanne and Erin for doing a lot of work to pull this all together, and everything that goes on behind the scenes to allow us to interact and work with you this way. And so have a great day, everyone, and hopefully we'll see you soon.